A refund is a crucial concept that arises when one party fails to fulfill their obligations under a contract. A refund is essentially the return of money or other forms of consideration paid by one party to another, often due to a breach of contract or a failure to deliver goods or services as promised. Definition of refund in contract law. A refund, in the context of contract law, refers to the repayment of money or other forms of consideration paid by one party to another, typically due to a breach of contract or failure to deliver goods or services as promised. A refund may be claimed by the party who paid the consideration, usually the buyer or the consumer, when the other party, typically the seller or the service provider, fails to fulfill their obligations under the contract. Types of refunds in contract law. There are several types of refunds that may arise in contract law, including full refund. A full refund is the repayment of the entire amount paid by the buyer or consumer, usually due to a significant breach of contract or a failure to deliver goods or services as promised. Partial refund. A partial refund is the repayment of a portion of the amount paid by the buyer or consumer, often due to a minor breach of contract or a partial failure to deliver goods or services as promised. Pro rata refund. A pro rata refund is the repayment of a proportionate amount of the consideration paid by the buyer or consumer, usually based on the extent of the breach or failure to deliver goods or services as promised. Circumstances under which a refund may be claimed. A refund may be claimed in various circumstances, including breach of contract. A refund may be claimed when one party fails to fulfill their obligations under the contract, resulting in a breach of contract. Failure to deliver goods or services. A refund may be claimed when the seller or service provider fails to deliver goods or services as promised, either partially or entirely. Misrepresentation. A refund may be claimed when one party makes false or misleading representations about the goods or services, resulting in a breach of contract. Cancellation of contract. A refund may be claimed when the contract is canceled due to unforeseen circumstances or a mutual agreement between the parties. Refund policies in contract law. Refund policies vary widely depending on the type of contract, the industry, and the jurisdiction. Some contracts may include a refund policy that outlines the circumstances under which a refund may be claimed, while others may not. In the absence of a refund policy, the parties may rely on the applicable laws and regulations to determine their rights and obligations. Statutory refund rights. In many jurisdictions, consumers have statutory refund rights that are enshrined in consumer protection laws. For example, in the United States, the Federal Trade Commission, FTC, requires businesses to provide refunds or replacements for defective or unsatisfactory goods or services. Similarly, in the European Union, the Consumer Rights Directive provides consumers with the right to a refund or replacement for defective or unsatisfactory goods or services. Case law on refunds in contract law. There are numerous cases that have shaped the concept of refunds in contract law. For example, in the landmark case of Hyde v. Wrench, 1840, the English Court of Appeal held that a buyer was entitled to a refund when the seller failed to deliver goods as promised. In another case, Walton Stores, Interstate, Ltd v. Marr, 1988, the Australian High Court held that a buyer was entitled to a refund when the seller failed to fulfill their obligations under a contract.